Court, I'm gonna admit Mr. Jordan. So at least we see who these people are. Okay. Attorney Carl Jordan. Let's see. Okay, sir, that's pushing the button in the interview room.
Yeah, she wanted me to do that, the officer.
Okay, what's your name? Good morning.
Facey, F-A-C-E-Y.
Casey?
F is in Frank, A-C-E-Y, Facey.
Oh, Facey.
Yes.
Okay, all right then. Good morning. We'll be with you shortly.
Okay, thank you.
Okay. All right, Mr. Jordan, good morning.
Good morning, Your Honor. Good to see you.
You as well. How are you?
Fine, thank you.
Who do you have?
I'm here on Terrell Bland.
Okay, so Mr. Bland has a couple of cases. I don't know if you were aware of that.
Yes, I think he's got 3, I believe, correct?
Well, I have 2 that's on the docket.
Okay, 2. Okay, that sounds about right.
He may have something pending, but there are 2 on the docket. So, what is your P number?
57226.
6. Okay.
Your
All
Honor,
right, so
Mr.
give us
Walker did not make the list, did he? DeMontre Walker?
Oh, one moment. Let me check. No, I don't see Mr. Walker.
Okay.
Maybe this afternoon.
Okay.
All right then, but I'll note you down here. Carl. Jordan. Okay, so
Thank you, Your
we're
Honor.
handling some other matters this morning too, so just be patient with us. Thank you.
Of course.
Okay, all right. Oh, it's here. And DDC is here, so maybe we can get started. Okay. All right, again, good morning, Ms. Coyle.
Good
Mr. Messer is
morning.
here. Oh, you know what? I need to get my No, I'm sorry. Okay. So, Mr. Marat, are you guys ready to start with the KPS?
We are ready. The only thing we're not ready on is the MDOC interview. Mr. Reagan should be zooming in shortly to interview them.
Okay,
But on the other KPS matters, we're ready.
all right, then we'll set things up
Ready,
so Judge Williams can get started. Hold on.
Perfect.
All
Thanks for
right.
bearing with us, Judge.
Good morning, Mr. Vincent.
Good morning, Magistrate. Good to see you.
You as well. All right, DDC is here. What you need, Officer Campbell? What? Oh, the walking? Ooh, okay. Which two do you have?
I have 14.
Okay,
and, 13.
13, 14, okay. Okay, thank you. All right, let's submit Mr. Reagan. Good morning, Mr. Reagan. All right, and DDC, good morning.
Yeah, you know what? I'm just gonna zoom in upstairs because that's probably what he's gonna be doing, and that'll be closer. Can you just hand me my? Is that my phone or your phone?
It's mine.
All right, then mine's upstairs. So I'll
Well,
just
then
zoom
how do you
in.
gonna know the, oh, you just gonna listen? Oh, and then you gotta sign the,
I got this. Oh,
you gonna have to sign the, pretrial release orders.
well, I'm just upstairs. I come down and sign them.
Okay.
Yeah, that's not a big deal. Yeah.
All right, so let's.
I'm trying to think about like
Oh, right.
how he would be doing it.
Okay,
But you know, y'all also got a lot today, so I don't want to slow you down either. Let me just call some cases and get this over with.
okay,
I'll do it right now.
yeah, okay. Let me just make sure, okay, Mr. Jordan and DDC, because I don't know, are
Jordan's
they
cases are
familiar?
older. And
DDC,
Don't jump on.
because let me let them know, we need to, and then they can line them up.
oh, okay. Yeah.
Okay,
Is there anything you need?
DDC? Camera one, can somebody chime in? DDC male camera one,
I don't.
hello,
Yeah.
good morning. Okay, can you check, can someone, who am I speaking with?
Officer Gowdy. We got
Officer Dolly?
Bird.
Good morning. Okay, so we have a list of individuals that we need to go first. Because we're gonna do the felony KPS arraignments first, okay?
Okay, yep, sure. Who you got?
All right,
Walking in.
all right, so we have Aaron Perry. We have Johnny Oram,
Where are they?
he's number 3, Johnny Oram, oh, I'm sorry, he's MDOC, so not him.
Yeah, Judge
Then
Hall
we have
does the handle sobriety.
Ahmed Gross,
He's
he's supposed to be by Zoom, okay.
Individuals that work with the court.
We have Leonard McLaughlin,
Traffic. She handles.
got it, okay,
Thank you.
and he's in Wayne County. Travis Rogers. Jermaine Bird, he's supposed to be a walk-in, he's here. Okay, and then this is Wayne County Jail. What is
I
that?
think that's it.
Okay.
It's only one thing.
All right, so we'll go ahead and get started.
And Your Honor, before you
You
do
want
that, breakout room with MDOC.
Okay, give me a moment.
So you only want to do those two?
I gave you the names, Perry
Well,
and Gross. It looks like the other ones, let's see, McLaughlin.
so the only two names
Okay, then give me one moment.
right here.
Good morning, Your Honor. Dawn McLeod appearing on behalf of the people.
Yeah, cases.
Good morning, Your Honor. Yeah, on behalf of Jeremy, is your first and last name for the record.
Is somebody else, in another courtroom?
No, that's Phil.
Phil, I think you might be.
Oh, I'm sorry. No, I'm sorry. I'm just ready to go in the breakout room with RGC.
Okay, all right, give me 1 minute.
Thank you, Judge.
Okay, all right, so Phil, which individual do you need to interview?
The Michigan Department of Corrections, Your Honor. Mr.
Okay,
RGC.
yep.
To see if they're.
Mr. Orm, Mr. Orm, Johnny Orm.
Okay, all right, you should be in there.
Thank you.
Thank you. Okay, sir, at DDC, what's your name? All right, good morning. Hold on, please. Okay, that's Mr. McAuliffe.
Okay.
We'll get it worked out.
All right. All right, this is, can you guys hear me? State of Michigan versus Leonard McLaughlin, case 1-8-452-29701. Today is the date set for an arraignment. Sorry about that. Today is the date set for an arraignment. Appearances, please.
Thank you, Judge. Good morning. Always good to see you. Steve Vincent for the people, Peace 71917.
And Ryan Marad, P836665, on behalf of Mr. Leonard McLaughlin, we will reading and stand with you. Mr. McLaughlin's been advised of this rights.
All right, Mr. McLaughlin, sir, could you state your name for the record, please?
Leonard McLaughlin.
All right, thank you, Mr. McLaughlin. Today is the date set for an arraignment. Mr. Murad, how are we proceeding?
Judge, we waive any formal reading and stand you to the charges.
Okay. Mr. Vincent Esteban.
Thanks, Judge. Judge, you're going to have to explain something to me, though, because this is a misdemeanor capias. So is the felony arraignments courtroom not handling misdemeanor capiases now?
I don't know, but this one is before me right now. It's
Just so I know in the future.
yeah. For the future, I believe that these are just going to be done as to felonies. But, you know, as you know, there's a number of cases this morning, and this matter is before me. I'm going to hear it. Bond's currently set an interim bond of $10.
Okay. And Judge, thank you for the explanation. Judge, I have 5 failures to appear in this particular matter. I have failures to appear starting right out of the gate, right after the arraignment here, where this individual was given a cash bond in the beginning, only to have it lowered, failed to appear, and then he was basically out for 2 years with a warrant being held against him. Then he was arraigned on that warrant, and he failed to appear once he got a personal bond. And it's a pattern. I have the most recent failure to appear in July of 2023, but there were actually two failures to appear in 23, one in 22, one in 21, one in 19. So unfortunately, Judge, you know, I know it's only $10. Maybe Judge, putting monitorization on this individual, seeing as though this is a six-year-old plus case with all of these failures to appear, but we would either be asking for monitorization or for this bond to be continued.
All right, Mr. Murad Esteban.
Judge, this bond, I advise that Mr. McLaughlin spent some time in the Wayne County Jail based on a probation violation. Had everything, we've had the opportunity to go over with him, his obligations to court. I don't have a justification for his previous failures to appear. I would ask ultimately for you to consider a final opportunity for him to come into compliance and come to court. This is still not adjudicated. It's, as Mr. Vincent indicated, a 7-year-old case. I'd ask for personal or for the bond to continue.
Setting the bond at $1,000 personal with GPS tether house arrest while this matter is pending. Mr. McLaughlin, are you working right now?
Oh.
All right, stay at home until this matter is resolved. The next date is going to be June 18th, 2025, before Judge Stafford Jones. The reason I'm setting this tether is because there's 5 failure to appears. I don't know what to tell you. This matter has to be resolved. This is from 7 years ago, excuse me. That concludes the hearing.
Judge, I understand the tether. Instead of the house arrest, would you consider curfew?
No.
Thank you.
Well, I will consider it, but I'm not doing that. We got some traffic tickets too. I'll call him. 1 second. You got a list of the tickets or?
Yes. they're right.
Also calling State of Michigan versus McLaughlin, case SP 131-2929, Z 798-521, Z 798-837. Today is the date set for an arraignment, setting aside any warrants, entering not guilty pleas on Mr. McLaughlin's behalf. Setting these matters on a date before Judge Wagner, June 20th, 2025. There's no bond on those matters. Just note, sir, that your date before Judge Wagner on the traffic tickets are June 20th. Just zoom in like you did to, we'll give you the Zoom information. And that concludes this hearing.
This was McLaughlin.
All right.
Say your full name now. Aaron Lorenzo Perry.
Mr. Perry, can you hear me?
Yes, sir.
All right, this is State of Michigan versus Aaron Perry, case 24058989901. Today is the date set for a, what is that? An arraignment. Appearances, please.
Lisa Coyle, hearing on behalf
got
of
two
the
cases?
people. Good morning.
Ryan Marat, P83665, on behalf of Mr. Perry, waive the reading and stand mute. Judge, there are two matters, one KPS, one never arraigned.
All right, also calling case 245949501. Is that the one that I called? This matter is just scheduled for an arraignment. All right. Mr. I guess appearances, please.
Lisa Coyle, appearing
Or
on
did-
behalf of the people.
And Ryan Marat, P83665, we also waive the reading and stand mute as to this matter, Judge.
All right, I guess we'll start with the matter that is in capious status, and that's case. That is the stalking, aggravated stalking 240599801. Mr. Murad asked to bond. Bonds currently sit at 10,000 cash as surety.
Thank you, Your Honor. Ultimately, as the bond, I'm going to ask the court to consider reduction. I see Mr. Perry has his hand up, sir. I'm going to advise you not to make any statements at this time. But Judge, you know, I don't have a good enough excuse as to why he appeared, but I can tell you what was going on at the time. He's a caregiver, was a caregiver full-time. He also suffers from his own medical issues, takes a plethora of medication. There's not an extensive capious history on his behalf. I'm not aware of any criminal convictions. I'm sure that people will correct me if I'm mistaken. Other than these two matters, I don't think there's anything pending. I don't believe he's on probation or parole. He's a stable resident here in the city of Detroit with his uncle. Indicates that he doesn't know who the complaining witness is. I think both cases have incident dates of 2024. My ultimate request is going to be a personal bond, Judge. I'd understand if you impose a tether, but I don't think it's necessary at this stage. I would just ask for personal bond and no contract.
All right. For the people, ask the bond.
Your Honor, since this incident, he has picked up the second case, which involves shooting at police officers. So he was so we have one here. This is a case in aggravated stalking in which there was a PPO in place that he was later arrested at an Amico gas station. It's not a situation where he turned himself in. He failed not to come to court while he was out. He committed another crime. That PPO was served in November 23. This occurred in December, right within a month after that PPO was issued and served. So, Your Honor, and then he failed to appear from September of 24. So I'm asking for that bond to remain in place at this time.
I had got that court case dismissed. Like,
Sir, no. Not gonna, I don't want you to do that.
All right, so this is what the way that I see it. As to case 24059989901, the aggravated stalking case, I have at least the start of the date of the offense at the end of 2023. That matter was arraigned at some point in 2024, and the $10,000 cash as surety capious was entered after two failed probable cause conference attempts that Judge Jefferson set, and then she set that cash bond as the defendant wasn't coming to court. And we'll get to the new case, but the new case has a date of the offense that precedes when he was arraigned on this stalking case. So I don't know, unless there's a third case that I don't know about, I don't know if there are any other pending cases. So I'm assuming that that's not, this case just has not been arraigned, but it's a date of offense of May of 2024. As to the stalking case, that the bond was set at 10,000 cash as surety. That bond was set in September of 2024. I don't have an excuse of why the defendant did not appear. But I do know that there is a,
They got the wrong
I
address.
do know that,
I'm sorry.
I'm gonna mute you, Mr. Perry. I do know that there were at least two non-appearances on an assaultive matter. I'm gonna set the bond or keep the bond at 10,000 cash as surety, and this matter will go before Judge McConicle for redetermination, and then back to Judge Jefferson on that docket. As to case 24059-45901, Mr. Murad Esteban.
Esteban, Judge, similarly, this is a matter from last year, almost a year ago. He was at home taking out the trash when he was picked up on this warrant. He's a caregiver, works 4 to 5 days a week from 9 a.m. to 7 p.m. He takes 3 medications daily, suffering from high blood pressure, among other things. Your Honor, he didn't know about this not in custody warrant. He indicates that had he known about it, had somebody contacted him, had the mail came to the correct address, he would have presented himself accordingly. Unfortunately, that hasn't happened. Given the age of the offense, Your Honor, the lack of criminal convictions, I would ask the court to consider personal bond here.
Ms. Coyle Esteban.
Your Honor, the people in this matter are asking for a 50,000 cash surety, tether house arrest. But I don't know if he has a house because he allegedly was an illegal squatter at the Pearson address. Officers go to that address, they hear gunshots, 4 of them, 2 more, observed him. They observed him himself shooting a handgun in front of that Pearson Street address. He turns allegedly toward the officer saying, "You got 5 seconds before I shoot you." They told him to drop the gun and he stated "F you" and began to reload, Your Honor. They did speak to the second suspect who was also there. Based on the information, they executed a search warrant 5 days later. The defendant was not present, and that's when the co-defendant, the alleged second suspect, was taken into custody and spoken to. So at this point, Your Honor, people believe, even though there is a year since this offense, it appears that this warrant was issued right after, and that this is highly assaultive, highly dangerous. We have gunshots, we have him pointing a weapon at officers. So I'm asking for that 50,000 cash surety as well as a tether house arrest.
Judge, my only response is I believe it took 4 months for the warrant to be issued after this election.
When was the warrant issued?
Warrant was issued September of 2024, and the date of offense is May of 2024.
That's right.
So what were you in court in September of 2024 on the second matter?
It was never arraigned.
Never.
This was just sitting in a not in custody file. It never came to anyone's attention.
Is the defendant on probation, parole, or awaiting sentencing on another case?
No priors.
I'm gonna set the bond in this matter at $100,000 with a GPS tether.
100,000 personal, Judge?
100,000 personal, excuse me, with the GPS tether. My reasoning behind that is that this matter is taking place last May. There were another case that was going on at the same time. There is a capious history on that second case. I'll give Mr. Perry an opportunity to be before the court on this matter. That case is scheduled before Judge Jefferson as well. The next date is June 13th, 2025, before Judge Jefferson. On the stalking case, the next date is going to be Monday, June 9th, before Judge McConicle for redetermination, but it has the same PCC date as this matter, so that's going to be June 13th as well. Is there anything further as to Mr. Perry?
Question. I have, Your Honor, what are any restrictions on that tether?
No contact with the complaining witnesses or that Pearson address if he's not a legal resident.
So there are no restrictions on the tether, is what you're saying, just a location tether.
It's a location tether, yes.
Thank
And Judge, I have the Pearson address as his address. I know there's issues with squatters' rights and these things. I just asked the court at this time not to consider imposing that, as I think that might be more of a civil issue with regard to his.
He can resolve it civilly, but that's what's going on right now.
No contact with Pearson.
No contact with that Pearson address. All right.
Nothing further.
All right, then that concludes the hearing.
Judge, Judge, do you have Mr. Orm in the waiting room from the MDOC?
Yeah, let me get Mr. Orman out.
That's a quick one.
I think it is. Oh, man. I don't have him in the waiting room. Do you want to waive his presence?
I will waive his presence, Judge. I will waive his
He
presence.
might be in a breakout room. Here we go. I got him. Sorry about that.
That's okay. V, what you-
I got him.
Bills are hot.
All right, gentlemen at the DDC, can you tell me your name?
Yes, Terrell Antonio Bland, Your Honor.
All right, thank you, sir. Hold tight. All right, Mr. Orman, can you hear me?
Yes, sir. It's oral.
Mr. Orman? All right. This is State of Michigan versus Johnny Orman, case 2557277701. Today is the date set for an arraignment. Appearances, please.
Hoyle appearing on behalf of the people.
Judge Philip Reagan, on behalf of Mr. Johnny Orm, who is present for arraignment, Judge.
All right. Mr. Reagan, how are we proceeding today?
Judge, there was a capious issue back on May 14, 2025. Mr. Orm was in the MDOC, Judge. They set a bond at 1,010%. So I'm just asking that we continue, we give him another PCC date, Judge. And I mean, I don't know what to do, just to mark the file that he is in the MDOC so they won't capious him again.
Okay, Miss Coyle has the bond.
I am also asking that the court to continue his bond. He's on a parole hold.
Yeah, but Judge,
So
okay, go ahead.
let me ask, no, wait, Mr. Reagan, this is where I'm at. So first of all, is my understanding he was in custody at the time of the capious?
Correct.
Okay, so I'm gonna make a record, and I know this from MDOC at this point. I pulled this up. That warrant was issued. That warrant was issued in error. It should not have been issued a warrant. So I'm going to try to, make this record so this does not get added to a capious history. Bond is currently set at 10,000. Strike that 1,010%. Do you want me to continue this cash bond so you can receive credit?
Yes, Judge.
Okay, so I'm going to set continue bond at 10,010%. Only so the defendant can receive credit while he's in custody. The next date is still the redetermination hearing on June 9th. And then we'll have a note and we'll order a writ for the June 20th date before Judge Taylor.
So Judge, the new PCC date is June 20th?
Yep, and I think that was to allow some time to make sure that he's before the camera.
Okay.
If he's in custody.
Sure. So we have an exam date of the 27th?
Exam date is the 27th, yes.
Thank you so much. I will contact his lawyer as well, Judge, and to let her know. Thank you very much.
All right. Anybody else? The young lady that's at Wayne County, can you tell me your name?
Say it again.
Candace Young.
That's not a case. It's just a 2021 case.
Hello, Judge Williams.
Hey, Miss Maribel, how you doing?
I'm doing fine. I'm here, Aaron Perry.
Oh, we just finished Perry.
I was retained on it and I had did appearance on it.
Oh, I'm sorry. 1 second.
I was caught up. I'm actually on vacation, but I was caught up in Judge Robinson courtroom. He didn't tell you that he had attorneys.
Didn't tell me.
No, Mr. President, he never let us know.
And I don't have the appearance on.
Okay, because my clerk filed this morning. What kind of bond did you give him?
He's got Judge Jefferson's bond of 10,000 cash and surety continued on one case, and he has a personal bond on the new arraignment.
Okay, thank you. I'll take care of it. Bye-bye.
All right. Did we get gentlemen at the so I got Sneed, who's a new case. I've got Miss Young, which is a new case, and Mr. Terrell. One more time, gentlemen at the DDC, can you tell me your name?
Terrell Antonio Bland, Carl Jordan is my lawyer, Your Honor.
Mr. Bland? Mr. Jordan, I'll let you do that one since Mr. Jordan's here and you know, it looks like I don't got anybody ready on the other ones.
Oh, okay. Did you want to say, DDC didn't have it, DDC got a name, so they were.
Oh, I'll come back.
They had to come
Mr. Jordan's here, so you can get him out of here and then, you know, I'll just check in upstairs and come back and finish the rest.
Okay, did you sign these? Not
I
yet.
didn't sign anything.
Oh,
I
I
just put
signed
them to the
the
side.
Okay,
You just throw them to the side. We'll take care of them. I'll make sure it gets signed.
okay, we'll put this one on here.
Okay.
Let it be signed. All right.
And I got these two. I did Orm and Perry. So I put those all over here. That's Mr. Young is up there now. And I'll be right back. Sorry about the confusion.
That's all right, so working out. Good. All right. Okay. All right, good morning, everyone. We had a new procedure we started today, so thank you for your patience. To get it worked out. Okay. All right. So, Mr. Jordan was on, Carl Jordan. Okay, and do we have Mr. Bland?
Your Honor.
That's you, Mr. Bland? Okay, so I'm just getting on to figure out who's who. Mr. Jordan, have you spoken with Mr. Bland, or you need a breakout room, or you're okay?
We're ready to go, Your Honor.
Yes, sir.
Okay, all right. Like Mr. Bland has two cases. Okay, sir. Sir, state your full name for the record, please.
Terrell Antonio Bland, Your Honor.
Okay, good morning. The court will call case number 25058000501. The people of the state of Michigan versus Terrell Antonio Bland. Mr. Bland also has another case. Court is calling case number 25058000401. The people of the state of Michigan versus Terrell Antonio Bland. May I have your appearances, please?
Lisa Coyle, appearing on behalf of the people. Good morning, Magistrate, as well as Mr. Jordan.
Good morning, Your Honor. Good morning, Ms. Coyle. Attorney Carl Jordan, P 57226, appearing by Zoom on behalf of Mr. Terrell Bland Mr. Bland is also appearing by Zoom, and this is with our consent, Your Honor.
Okay, and how does he stand as it relates to the arraignment, Mr. Jordan?
Your Honor, Mr. Bland waives a formal reading of the information, and he asks that a not guilty plea be entered on his behalf.
Okay, the complaint warrant, to waive the reading as it relates to the complaint warrant. And has your client been advised of his constitutional rights, Mr. Jordan?
Yes, Your Honor.
Okay, all right. And the court will enter a not guilty plea on behalf of Mr. Bland. A bond recommendation, Ms. Coyle.
I'm going to argue my bond recommendation as to both cases, Your Honor. So, as the court can see, the case ending in 05, that case occurred back on April 12th of 25. It is a reissue. It was dismissed for the complainant failure to appear, Ms. Searles. The complainant and the defendant have a child together, and they also, my understanding is she is also currently pregnant with their baby. Based on the allegations that occurred on June 1st, 25, I spoke with the prosecutor's office. They and DPD believe there has been an escalation of assaultive contact between the defendant, Mr. Bland, and Ms. Searles, that they felt that the case warranted to be reissued based on the facts and circumstances. So that case back on April 25, which she allegedly refused to have sex with him. They had an argument. He punched her repeatedly in the head and the face, and he got a handgun and threatened to blow her head off. She left. They executed a search warrant a couple days later. 9mm Ruger was recovered, as well as some ammunition. The case on June 1st, same complainant. There was an argument. She attempts to leave. He then allegedly grabs a belt and places it around her neck. And he told her, if you call the police, I'm going to choke your ass out. He then said he was going to bury her and their children next to her deceased mother. She then ran from the house. She fell, hitting her mouth, causing an abrasion and swelling, and she called 911. As noted also in the IR, they executed a search warrant for guns and to DPD on the 4th, and he was arrested. They also noted in their IR that they believe is an escalating issues. The fact is, after this occurred, 10 hours after the assault, he called DPD to get his gun back from that FA case that was dismissed back with the allegations coming from April. So involving that same complainant, they felt that was extremely dangerous. The fact that day after this assault, he's coming looking for his weapon. They're also noted in the IR back in September 22, she reported that he strangled her with an extension cord around her and struck her multiple times in the head, again for not wanting to have sex with him. There was also a complaint made with the police back in October of 23, same victim for domestic violence, and in March of 24, a CSC 3, same victim. This is unfortunately a typical cycle of violence, that the violence has been escalating during the relationship. So the people believe, as well as DPD and the Wayne County Prosecutor's Office here, they believe that the complainant, Ms. Searles' life is in danger. I'm asking for the present case that occurred, ending on 36, that occurred on June 1st, for a $100,000 cash surety, tether house arrest to a location other than this home that they reside in. As to the previously dismissed case, Your Honor, the people are asking for a $20,000 cash surety, tether house arrest, and of course, no contact with the complainant in this matter. Thank you.
Okay, you're welcome. Mr. Jordan, your response?
Your Honor, I would note that I was in court with Mr. Bland recently. As Ms. Coyle indicated, it was in April. The case was dismissed after Assistant Prosecuting Attorney Shelley Drain spoke to the complainant, Ms. Searles, and Ms. Searles stated she did not want Mr. Bland to be prosecuted she stated that, and I believe she also stated she was not in fear of Mr. Bland at that time. Mr. Bland at first was ordered not to have any contact with the Nashville residents. However, after Ms. Drain spoke to the complainant, it was ascertained that Mr. Bland is the one that lives there. He was allowed to go back to the Nashville residence. And again, Your Honor, Ms. Drain spoke to the complainant, and not only did she state that she did not want Mr. Bland to be prosecuted, but she failed to show up to court. So Mr. Bland has any problem showing up to court. Mr. Bland also has complied with all the conditions of bond in the past. I would ask for a personal bond, Your Honor. He will show up to court. The question is whether or not Ms. Searles will show up to court. And I don't believe that he is someone that cannot be trusted. I believe he is somebody that can be trusted to show up to court and comply with all the conditions. We're going to respectfully ask for a personal bond. I believe that is what he was given in the prior case. It was dismissed, and he showed up to court every single time. Thank you, Your Honor.
Okay, thank you. And so, Mr. Jordan, does your client have somewhere else that he could reside?
Particular point, he does not have any place other than the Nashville residence that he. That
Does
is
Ms.
where
Searle live at that location?
Ms. Coyle will have to follow up on that, but that is not where she lives. That is where the complainant, that is where the defendant lives, Your Honor.
Looks like that's where the incidents keep happening at. Ms. Coyle, do you have the complaining witness address at a different location than the Nashville?
I'm just looking, if you give me a moment, please.
Yes, you have.
Thank you.
2 minutes. Okay, I am looking at the investigators report.
I do have her information all going to the Nashville address.
Okay, what about the investigators report makes reference to a state fair location? What about that? Did you see anything
Hold on,
PBK related to that?
getting in there.
Okay,
I
so the report from
see Nashville on the one from 4/12/25 as well.
but the more recent one,
I know,
I see a different
I'm
location.
looking at all of them. And where I looked
Okay.
where the victim services information went. So I wanted to see, that to me is they get that information from her. So let me see if there's anything different. That information does give a different address on that, and the victim services. Let me check one other thing.
Yes, please.
Because I do not want to be wrong. I don't. I mean, this is a guess, and that's what bothers me. I can give you the information I have, but to me, I'm not. She does have on, as of 6/1/25, a different address as well on the investigator's report, the same one that went to the victim in victim services. So she may have moved from that location since April. But in April, she was there, it shows, and then now she's giving a different address 6 weeks later.
And although, Your Honor, she may have given the address in April of Nashville, I don't believe that was ever her address where she lived. They do have a child in common, and she would go there often, but that is not where she lives. That's where the defendant lives.
Okay, but there's a history between the parties as it relates to some of these reports that have been filed, irrespective of the fact that she has not appeared. And while she may indicate to you, Mr. Jordan, or at least on the record somewhere, that she doesn't want to prosecute and she is not afraid, somehow these matters keep coming before the court. And so that's very concerning to the court, considering the assaultive nature of these particular offenses. One is assault with a dangerous weapon, and then and a felony firearm charge attached to that. That's a mandatory 2 on that one. And then the most recent one from June the 1st, there's a felonious assault and domestic violence. And so it's also domestic violence on the one from April of this year. And so her not appearing in court, that's her choice, but the court currently has some very serious allegations before that involve a weapon on one, and what was the other felonious assault? Because again, it appears that this matter is escalating and the level of the language that's being used at the time of these assaults, indicating that I'll shoot you and I'll kill you and I'll bury you next to your deceased mother. That's alarming to the court. And I don't know whether or not such action will be carried out, but based upon what I'm reading, he definitely poses a danger to the community. And the court does find by clear and convincing evidence that some sort of cash bond is necessary. And the court is not going to impose $100,000 cash bond on the case number ending in 005, dated 6/1/2025. The court is going to set a $50,000 cash surety bond.
Would you consider 10%, Your Honor?
He's gonna have to have a tether. He's gonna have another case as well.
Would you consider a
Ms.
10% provision, Your Honor? Again, he's always complied with the terms of bond. This new case was not picked up while he was on bond.
I understand, but the cases are back to back, and it looks like it's a prior CSC 3 dismissed, a prior DV in 23. So every year, we have him coming back before the court. So something is going on. This is apparently a toxic relationship based upon these allegations. So not at this time, Mr. Jordan, but he will have a bond redetermination hearing in a couple days. He is going to have a bond set on the other matter as well. So with that, let me just continue on with case number ending in 005. Mr. Bland, the court again is going to set a $50,000 cash surety bond. You have good counsel, Mr. Bland, but the court is concerned about the nature of the charges. It's not only one case, it's two, and then there appears to be multiple contacts in the past as relates to this very same complaining witness and the threats that have gone out, at least the allegations concern the court. And I do find that a cash bond is necessary. So you cannot have any contact with Artany Searles. And so I don't care if she wants contact. At this point, the court is ordering you not to have any contact with Ms. Searles. Now, Mr. Jordan and Ms. Coyle, the court is concerned about whether or not, I'm not sure if she lives there or not. She's given a different address. However, it appears as you look at the reports that it keeps happening at that location. Something keeps happening at the Nashville location. So at least for now, Ms. Coyle,
Yeah.
do we show that is her address? The State Fair address is her address?
That is what on the victim services as well as, yes, so that's what it is on the IR, yes.
Okay, the most recent one indicates it appears that she might be at a different address. I'm not gonna not order him to go to his home, but you do have a no contact provision in place, Mr. Bland, which means you cannot have any contact with Ms. Searle, not on Nashville, not on State Fair, not on 7 Mile, nowhere, no contact. So that's as relates to that file. As it relates to file number 25058000401. On that file, the court is going to set the the 20,000 cash surety bond. And you again may not have any contact with Anthony Searles. And you're not to possess a firearm or any other dangerous weapon. The court will also include that condition on the file ending in 005. Do not possess any weapons. Okay. Is that affordable or unaffordable for your client, Mr. Jordan?
I believe it's unaffordable at this point, Your Honor.
Okay, then he'll have a bond redetermination hearing on Monday. That will be before Judge McConicle or Judge Williams. So that'll be 6/9 at 9 o'clock by Zoom. And Mr. Bland, your attorney can readdress the bond issue at that time, but that's where it stands now. Let me give him his court dates. He has for both files, probable cause conferences scheduled for June the 17th at 8:30. Those will be by Zoom before Judge Jakay. Then, Mr. Bland, you have the right to a preliminary examination. That is scheduled for June the 23rd on both cases, before Judge Jakay at 8:30. But those will be in person. Okay, there's nothing further. That concludes this matter.
Your Honor, Your Honor, the bond hearing is in front of Judge McConicle on Monday?
On both files, yes, bond redetermination hearing on
Thank you.
both files on the 9th at 9 o'clock.
Thank you.
I have a question,
Okay.
Magistrate, I'm sorry. The tether, does it have any restrictions?
Location.
Okay, and it's on both
Contact.
cases, correct?
It is on both cases. If I
Thank
didn't say
you
it on
very
the other,
much.
the tether will be
Thank
on both
you.
cases.
Thank you.
Thank you, Your Honor.
Okay, thank you, Mr. Jordan. Take care. Okay, give me 1 minute. Make sure I got the files straight here.
Judge, I'm sorry, I don't mean to. I just want to make sure the Zoom didn't zoom in the waiting room. Ahmad Gross.
Excuse me, Your Honor.
Yeah.
Did, Judge Williams,
He said he's coming back. He said he.
No, is he done?
Oh, Orm.
They're calling.
I did hear. Let's see. I thought I wrote a bond amount down on Orem. It was 1,010%. So he completed him. Yes. I don't know that he signed the paperwork, but he did complete it. Oh, hold on. Oh, 10,000, 10%.
No, she said she thought.
Oh, yeah, I do have 10, 10 and then a comma. So yes, 10 looked like 10,000, 10%. You're welcome. Okay. That's on one file. Yes. Walk in. Okay. Okay, that's the other one on there. All right, we got a lot of people here. We got some walk-ins, so we asked them to be patient with us this morning. Thank you. Okay, so, Deb, you're holding the paper up. Who do you have?
Good morning, this is Miss
Morning.
Candace Young.
Ms. Young, I know Ms. Young has been up there a minute, so hold on. We usually wait on the women, but we're doing stuff a little bit out of order today. Candace Young, okay. And sir, that's just stepped up to DDC. What's your name? Sir, DDC? What's the last name? Heel? Okay, we'll be with you shortly. Thank you. All right. Ready on Young, the parties? Court is calling case number 2106112801. The people of the state of Michigan versus Candace Young.
Lisa Coyle appearing on behalf of.
Thank you.
And Ryan Murad, PA 3665 on behalf of Ms. Young. We waive the formal reading. Ms. Young stands mute. She's been advised of her constitutional rights.
Okay, the court entered not guilty plea on behalf of Ms. Young. Bond recommendation.
Your Honor, this
Coyle.
case dates back to 2019. No objection to 5,000 personal.
No objection, Judge.
Okay, the court will set the $5,000 personal bond. Ms. Young, that means you do not have to post any money. It looks like there are no special conditions. All right, hold on. All right, Ms. Young, you have a probable cause conference that's scheduled for June the 13th at 8:30. That'll be before Judge Jefferson by Zoom. And then you have the right to a preliminary examination. That's scheduled for June the 20th at 8:30. However, that will be in person before Judge Jefferson in the 36th District Court. Okay?
Thank you, Your Honor.
All right, that concludes this matter. Thank you. Hold on. Okay, let's see, sir, at interview, it says 12, interview room 12. Your name, please, and then I'll get to you, sir, at 10, all right?
Facey, Rashawn Facey, RASUN, Facey.
Mr. Facey, okay, we did see you earlier, hold on.
Yes, Your Honor.
Facey, now support, okay, hold on.
Hey, Rod, do you have this as an AG case?
Let's see.
Yeah, it should be felony non-support.
He'd be really lucky if it's an AG case.
It's an AG case.
Okay. thanks.
AGK. Okay, all right then. Sir, state your full name again, please.
Rashawn Facey, Your Honor.
Okay, thank you. Good morning. The court is calling case number 170-591-8901. The people of the state of Michigan versus Rayshawn James Facey. Appearances, please.
Ryan Murad, PA 3665 on behalf of Mr. Facey. We waive reading and stand mute. Mr. Facey's been advised of his rights.
All right, court entered not guilty plea on behalf of Mr. Facey. I forgot the people were not entering on this, entering an appearance on this. Okay, then as it relates to bond, Mr. Farad.
Judge, as it relates to bond, in order to deviate from the statutory requirement, I would advise that Mr. Facey is not gainfully employed at this time. He was in between jobs, falling within 200% of the poverty guidelines. I believe that sufficiently constitutes good cause to release him on personal bond, and I'd ask the court to do so accordingly.
Okay, the court will set a $30,000 personal bond. As the court does fine. Good cause to deviate, and he does have a probable cause conference scheduled for June the 25th before Judge Prentice Edwards. That will be in person at the Criminal Justice Center.
Thank you, Your Honor. We have nothing further.
Thank you. Okay, all right, then, sir, that's in interview room 10. Your name, please. Good morning.
Good morning, Your Honor. Kevin David Wysack.
Mr. Wysack. Okay, that's a KPS bond. We have to wait for Judge Williams to return on that file, so if you just be patient. The court appreciates that. Sir, interview room 11.
Good morning, Your Honor.
Good morning, your name? What's the last name?
Steed, S-T-E-E-D.
Oh, Mr. Steve, okay. Hold on, let me see. See those cases. All right, good morning. The court is calling case number 250-5724-001. The people of the state of Michigan versus Jamal Zachary Steed. Can I have your appearances, please?
Lisa Coyle appearing on behalf of the people.
And Ryan Marad, PA 3665, on behalf of Mr. Steed, we waive the formal reading and stand mute. Mr. Steed's been advised of his constitutional rights.
Okay, then the court will enter not guilty plea on behalf of Mr. Steed. My recommendation?
People recommending 10,000 personal. He's currently on probation, the judge now.
No objection.
Okay, the court will set a $10,000 personal bond. Mr. Steed, sir, while you're on bond, you are not to use any illegal controlled substances, so no drugs, okay?
Yes, Your Honor.
All right, then hold on for your next court date. And then I do recognize that we have some retained counsel in the gallery. I'll get to them soon. Okay, 10,000. All right. Mr. Steed, you have two court dates. You have a probable cause conference that's scheduled for June the 13th at 8:30. That will be before Judge Giles by Zoom. And then you have the right to a preliminary examination. That is scheduled for June the 20th at 8:30. However, that will be in person before Judge Giles in the 36th District Court. You understand your court dates and your bond conditions?
Yes, Your Honor. Did you say the first court date was when?
Your first court date, your probable cause is June the 13th at 8:30 by Zoom. Okay, if you can't get on Zoom, then you come directly to the courthouse in person, okay?
Yes, Your Honor.
All right, then have a great day. Okay, let's see. Then we're waiting on Wysack. Mr. Davis, good morning to you, sir.
Good morning. Morning.
I saw you in the courtroom earlier.
Yeah, Jimmy Fells, he's there in person.
Mr. Fells is in person. Can we have
Yes,
Mr.
he
Fells
is.
step up, and then Mr. Nasser, you'll be next. Okay, sir, state your name, please. All right, good morning. Okay, the court is calling case number 250-5737-801. The people of the state of Michigan versus Jimmy Fells. Appearances, please.
Thank you, Magistrate. Attorney Davis, Stevenson for the people, P71917.
Good morning, Maurice Davis, P76203, appearing with Jimmy Fells, who's present apparently as in person. I'll wait for the reading of the charges and please stand mute.
Okay, the court will enter a not guilty plea on behalf of Mr. Fells. Mr. Benson, by recommendation.
Magistrate, if you can just give me about 5 seconds here. Sorry.
Okay, time out.
I just had to put the charger here in my computer. I didn't want it to turn off, waste the court's time. I got to start by saying this. People do appreciate the fact that defendants walked himself in, and Mr. Davis is a very fine lawyer. With all of that being said, though, this defendant is a clear and present danger to the community. And what I have to do is and look to the community to keep it safe. This is being charged, Magistrate, as a high blood alcohol content as well as an OWI. And this defendant has a substantial history of driving under the influence and then subsequently being convicted. We're going to be asking for a 10,000, 10%. We're also going to be asking for an alcohol tether. Quite honestly, but for the fact that Mr. Davis is involved, as well as the fact that the defendant's walked himself in today, that people would have asked for a lot more. In this particular matter, and it happened earlier this year, the defendant caused a single car crash. He was the lone occupant in the vehicle. The police end up responding. This defendant's found to have a 0.326 blood alcohol content. 0.326, over 4.5 times the legal limit. This defendant has previously been convicted of not 1, not 2, but 3 under the influence and or OWIs. He recently ended up having an open container of alcohol in Ferndale in 2017. But magistrate, based on the fact that this defendant has a substantial history of getting behind the wheel while he's intoxicated, as shown by his convictions, and now we have the defendant on a freeway, on a local freeway, crashing with a blood alcohol content of over 0.32. We find him to be a danger to the community. He has a problem, clearly, but he hasn't rectified that problem. So we're asking for that cash bond. We're also asking for the monitorization.
Okay, thank you. Mr. Davis, your response?
Yes, Your Honor. My client, as the court is aware, walked in with retained counsel today. The cash bond is not necessary to secure his appearance. He promises to appear at all future court appearances. I don't know what him paying $1,000 would do to secure that besides take money out of his pocket that he needs to live on. My client is no longer drinking. He's no longer driving. He has someone who's present with him in the courtroom who drove him to court today. He's scheduled to enroll in inpatient treatment on the 10th. He recognizes his problem and therefore he's taking action to addressing issues that he may have. He's scheduled to enroll for at least 30 days on the 10th. So I was planning on making the judge who's assigned to the case aware of that, and I was going to ask for an adjournment after today's date. So he's addressing his issues. He's not a flight risk and no longer a danger to anyone because he's not driving. So I would just ask the court for a personal bond. The court wants to order some testing to begin after he completes his inpatient treatment. We're perfectly fine with that. But I don't want the court to order a GPS tether or an alcohol tether, and my client is sitting in custody waiting for that tether to be installed, and he's scheduled for treatment on the 10th.
Okay, all right, thank you. The court has heard the arguments, and Mr. Fail, sir, thank you for walking in to try to resolve this matter. You have retained counsels, so the court, takes that into consideration. But the court is looking at these prior offenses, and obviously, based upon these allegations, and there's a problem. It seems like you're trying to get it addressed, and that's a good thing. But the court has the responsibility of also protecting the community. The court is not going to impose a cash bond. The court is going to impose, and Mr. Davis, I don't know whether he's going to be in treatment or not on Tuesday. So, because oftentimes people will come to court and they have good intentions about what they're going to do, but sometimes they follow through, sometimes not. He has retained you, and so I know that you will encourage him to follow through. But for now, and if you can address it later, for now, he'll have to get connected to an alcohol tether. What the court will allow him to do, since he has retained counsel, is to report on Monday. Now, he indicated that he rode down here with somebody. Where are they? Okay, all right, so, you're no driving, sir. You cannot drive without a valid driver's license. And so, let me see. I don't see that they've attached a driving offense with this, but you're not to drive as a condition of your bond, and you're not to use any alcohol. Okay, so fears this might be a problem, and you, again, get the help that you need if it is. This is from January 2nd, 2025, and that's one of the reasons why the court is allowing you to report to the jail on Monday versus being taken into custody today, because you retained counsel and it's been a few months and you walked in. Other than that, you would have to be taken into custody today. You understand that? This is a high BAC. The court is concerned about it. If in fact you do manage to get into treatment, then your attorney can work out whatever he needs to work out with us, with the judge relating to your tether. But at this point, the court is going to order you to present yourself to the jail on Monday for alcohol tether, okay? All right, so his court dates, he has a pretrial that's scheduled for Judge Jones. That will be by Zoom on June the 18th at 8:30. All right, anything further, Mr. Benson?
No, thank you, Magistrate.
Mr. Davis?
No, thank you.
Okay, that concludes this matter, sir. Have a good day. Yeah, so he did. He got a, did I set the amount? I'm sorry. 10,000. Okay, thank you. I heard personal bond in my mind, but looks didn't catch up. All right. Here. Tether. Board. So, sir, I would suggest that you report by noontime on Monday. No later than noontime on Monday. Don't wait till the end of the day and then not get connected. So by noontime on Monday, you need to report for the tether. They'll give you the paperwork before you leave. Okay. Did Mr. Davis leave? Oh, okay. Okay. All right, let's see. We have somebody else that's here. Mr. Nasser, you want to step forward?
Yes.
Okay. Mr. Rod, you just be patient a minute. I'm gonna just. Oh, an interpreter. Okay, what's your client's name?
Ricardo Martillo.
Montilla. Okay.
Yes, please.
All right. Okay. Chief Judge, courtroom. You ready to resume?
All right.
Okay.
He said, how many do you have left of the cases?
That's Mr. Williams. That's Chief Judge. Oh, we still, he only did 3 of them. We have 1, 2, 3. We have 4 left. We can have DDC bring them. Let's see. I think the jail is, if they don't have anybody in their interview room, let's see, DDC. Let's see if Mr. Gross. He's supposed to be on Zoom, so I do see him on Zoom. And then Mr. Rogers. He's at the Wayne County Jail, but I don't see the jail ready on that one. And then Mr. Bird is a walk-in. Okay, ready on one walk-in. And then we did have, oh, he's still there, Mr. Whitesack. So it looks like 3 of them. And it was 3 of them we are.
Okay. Yeah. Okay, all right.
Oh, okay. All right, great. All right. So the court is, oh, we have an interpreter. First, I do need his name though. Can Mr. Montello state his name? Okay, hold on. All right, then, Mr. Interpreter. Your name, please.
Hector Solis,
Hector, spell the last name.
Solis.
S-O-L, Solis. Okay, raise your right hand. Okay, do you swear or affirm that you will interpret what language? Spanish? Spanish to English and English to Spanish?
Yes, I do.
Okay, all right, then you put your hand down. All right, the court is calling case number 2504524-001. The people of the state of Michigan versus Ricardo Montilla.
Good morning, Your Honor, and to your staff. May it please this most honorable court. Mohammed Nasser, P74485.
Okay,
Appearing on behalf of which Mr. Ricardo Montilla, who has identified himself in record. Defendant was waived the formal reading, stand mute. Humbly request the court to enter not guilty plea on his behalf. And he's been advised of his constitutional rights.
okay, before I do that, can we have the appearance from the people?
Good morning, Lisa Coyle appearing on behalf of the people. Thank you.
Thank you. Then the court will enter a not guilty plea on behalf of Mr. Montilla. Okay. By recommendation, Ms. Coyle.
Your Honor, I am not aware of a criminal history for Mr. Montilla. No objection to a $25,000 personal bond. No contact with Mr. Booker, the complainant.
Okay,
Please, court.
your response.
Your Honor, certainly I thank Ms. Coyle for her recommendation. Defense has no objection to same. I'm familiar with the. Certainly have no comment.
Okay. All right, the court will set bond at $25,000 personal. Typically for that charge, I would not, but it looks like based upon the IR, it involves some other activity that may not have been charged. So of course, a little concerned. It's a higher cash bond than I typically, I mean, higher personal bond than I normally would. But
Your
I will
Honor?
set it at 25. Yes, go ahead.
I don't mean to interrupt. Sorry, it's a Zoom. The co-defendant was charged with the felony, I believe.
Okay. All right. So it's a $25,000 personal bond. And Mr. Montilla, while you're on bond, you are not to have any contact with Cecil Booker. And you're not to possess or purchase a firearm or any other dangerous weapon. Okay. Understood? Okay, hold on.
Okay.
All right, so he has a pretrial scheduled for June the 18th at 9 o'clock. I'm sorry, 8:30 by Zoom before Judge Jones.
Understood, Judge.
If you can't connect to Zoom, make sure to tell your client to appear in person.
We'll make sure he comes to me.
Okay, all right, thank you. Then that concludes this matter.
Thank you.
Okay, so Mr. The interview room is here.
Thank you.
Okay, you're welcome. Take care.
Any further, Your Honor?
No, do you have your documents that you need?
I believe.
The court will get those to you. It's in the file. Okay, it's right here. All right, thank you. Okay. Thank you, Mr. Solis. Okay, all right, so, Mr. Wyzak.
Yes, ma'am.
Just to let you know, our chief judge is going to handle your matter, so he'll be down shortly.
Should
All
I
right.
wait, should I wait here or come back?
Yeah, no, you wait right there.
Okay.
Wait right there.
All right.
Okay. And then, sir, in the interview room?
Travis Rogers.
Oh, girl, here. Yes, Deb, who do we have right there?
Travis Rogers.
Okay, good morning, Mr. Rogers.
How you doing, ma'am?
All right, hold on a minute. Is he one of the? Oh, hold on. Let me see. Oh, this is a bond. Okay. Oh, okay, your matter is going to be handled shortly, sir. Thank you for your patience. Okay, so yeah, Judge, we're ready with these two here.
First time I've seen you in a robe on. Which are the cases?
Okay, these are the other ones, right? Those are cases. Okay.
Matt.
And these are the ones that he had signed. Miss Johnson.
Miss Johnson, can you call the KPS and just hand it back to? Oh, okay.
These are the ones that he didn't sign.
But these are done?
Yes.
It's in here?
Yes.
These are in.
Okay. That was the sheet he was using over there.
Okay, well, let me do one thing at a time before I mess up. Let's call the case and then to hand me the file after the case.
On case 200-590-8101, people of the state of Michigan versus Jermaine Bird. The defendant is charged with count 1, license plate registration title for unlawful use.
Are you Bird?
Arraignment on the bench warrant.
Why is it? Oh, this is a walk-in. Okay. Okay, pass it. All right, counsel.
Steve, it's great to see you. It's been a while.
Good to see you also. Yes, indeed.
Steve Vincent for the People, P71917.
And Ryan Marad, P83665, on behalf of Mr. Jermaine Bird, we waive the formal reading and stand mute. Mr. Bird's been advised of his rights.
Okay. And what is this is a KPS bond, correct?
Correct.
And what is his bond currently?
If anybody can tell me that, I would appreciate it, because I went through the register of actions and it wasn't specific. This is what I see, Judge. This was an adjudicated matter. He first had that license forgery. It was reduced down to the unlawful plates. He was given probation on that. I think this has to do with the probation violation. A lien was entered, but an amount was never given. Actually, in full candor, there was never even a failure to appear that was provided on the ROA. So I think there was a warrant that was issued. I appreciate the fact that the defendants walked in. It's been about 3.5, almost 4 years, Judge. So I think this is one of those where we can just give this defendant a personal bond. I'm sure he's going to take care of his matters and we can just move on.
Okay. Any objection from the defense?
No objection.
Madam Clerk, one question. Does he have a future court date? Let me hand that back to you. Okay. Okay, sir. You have a pretrial date of June 18 at 8:30 in front of Judge Kenyatta Stafford Jones. Your bond will be in the amount of $5,000 personal. Do you understand, sir? No? Okay. You have a Zoom hearing in front of Judge Kenyatta Stafford Jones on June 18 at 8:30.
What the charge of?
You pled, looks like you pled guilty for something in
Unlawful
2021. What was it? A
Unlawful
license
plates.
plate,
Yeah.
unlawful plates.
Judge, if I may,
Yes.
I think the case needs to properly be set for sentencing. I think what happened here is this was originally in the exam courtrooms. That's where the plea was taken, and then it was sent to be sentenced with the Honorable Judge Bryant. And unfortunately, I think there was a drop off. I don't know if his attorney followed the case or not, but I think it's properly supposed to be set for sentencing.
The matter will be set for sentencing for June 18 at 8:30.
Thank you, Your Honor.
All right, thank you.
This is where I'll stand mute because it's academic, but I had a different interpretation of it, but whatever, we got to the same conclusion.
Well, the sentencing recommendation is in the file, and so,
But it was a probation violation that ended up giving him the capias, so.
Looks like there was a scheduled for sentencing 8/9/21 and no appearance at that time. A warrant entry was requested, and then there's been no further action on the matter.
On June 18th, Judge Kenyatta Stafford Jones, in her
that's
infinite
fine.
wisdom, will handle this matter.
There.
All right.
Thank you.
Yes.
Now that the warrant is lifted, will I be able to, look at the CPL on?
No, you need to get your matter adjudicated on June 18th and get this case closed, and then you'll be able to go about your way.
Thank you.
Okay.
Thank you.
You're welcome. Yeah. Putting the cart before the horse. Can't get out of those streets yet. You guys get ready on the next one. Keep it as what it is.
Okay.
Let's keep it simple.
Okay. Calling case 210-575-1001. The people of the state of Michigan versus Travis Rogers. The defendant is charged with count 1, jail, possession of a weapon in, count 2, assault with a dangerous weapon, felonious assault, count 3, police officer assaulting, resisting, obstruction. Today is the date time for an arraignment on bench warrant. Appearances, please.
Thank you, Chief. Always a pleasure. Stephen, P7191.
And Rod Marad, P83665, on behalf of Mr. Rogers, we waive the formal reading and stand mute. Mr. Rogers has been advised of his rights.
Okay. Mr. Rogers, state your name for the record.
Travis Julius Rogers.
Okay. And Mr. Rogers' capias bond is what?
5,000 personal.
Okay.
And the reason being he was incarcerated. He ended up, I have, Chief, March of 24, he was sentenced on an R&O. He got 2 months to 2 years. So I don't have any problem. I mean, we can just continue this and move on, I guess.
Like 5,000 personal is continued. And you have, so you have a PCC scheduled in front of Judge Taylor for June 20th at 8:30. Thank you.
Thank you, Ron.
Thank you. Have a nice day.
All right, you too.
I got to make the most of my time in front of the chief, seeing as though I don't get to see him and read determinations anymore. So I really got to make a good impression here.
Get out of here, man. Anything else?
Mr. Gross is on Zoom.
Yeah, Mr. Gross, is he on Zoom? Is he on there?
He was, I don't know. Do we see Gross, am I Gross?
We have Mr. Wysick on the screen. He's also a capias. He's over at the CJC.
Okay. He has tickets also. Yeah, wait a minute. Okay, so before this nonsense I just started, how would you handle this if this was yesterday?
Tickets first.
Okay. Let's do the felony, and then I'm gonna move off the bench and let the judge let the magistrate get the tickets. So we're only dealing with the felony case.
Hey, Chief, to get you out of here, earlier, Mr. Gross, I think he was a walk-in, but he posted. So that's just going to be continued.
Okay. Well, so we'll call that one next. No, call that now. Call the, call Gross, please.
I don't know if he's here.
You can waive, if he's already posted, you can waive his appearance. They say he's posted already, so we'll just continue his bond.
In case 2505765101, the people of the state of Michigan versus Ahmad Gross. The defendant is charged with count 1, weapons carrying concealed. Today is the day and time for an arraignment on the bench warrant. Appearance, please.
Steve Benson for the people.
And Ryan Murad, PA 3665, on behalf of Mr. Gross, asking the court to waive his appearance as he's posted bond.
Appearance will be waived, is my understanding. He's already posted. His PCC is June 13th in front of Judge Robbins.
Thank you.
Thank you. All right.
Thank you.
All right. And then we'll call this last one.
Calling case 2505596101, the people of the state of Michigan versus Kevin Wyatt. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle, second offense notice. The defendant has a habitual offender, fourth offense notice. Today is the day and time. Set for an arraignment on the bench warrant. Appearance, please.
Judge, always a privilege. Steve Benson for the people.
And Ryan Murad, PA 3665, on behalf of Mr. Wysek, we waive the formal reading. Mr. Wysek stands mute. He's been advised of his rights.
Okay. So my understanding is a 2,510% bond. Is that correct?
Yes,
correct.
All right. Argument.
Chief, you're going to love this. So he fails to appear at his first exam. Then a bench warrant was issued. He gets that continued. He goes to redetermination. He gets Judge Williams to lower it to a personal bond. And then what do you know? He fails to appear at his next exam. So he's had multiple chances at this. We would be asking you to continue this.
Your Honor, on behalf of Mr. Wysek, as I don't have a justification or excuse for his failure to appear, what I can tell you is that he's been gainfully employed doing construction for approximately 12 years. He lives with his wife and his 2 children. This is a non-assaultive case. Despite his gainful employment, he can't post the 250. I think I'd be inclined to ask for a personal with tether as opposed to the 250, just knowing that he can't post it. And I think that would assure his appearance, Your Honor. So that's my request.
We haven't heard the arguments of counsel. Court, based on flight risk aspect at this time, the court is going to continue the bond as set. And when is his redetermination hearing? Is it set already? Or is his bond redetermination hearing set already? Or okay. You will have a bond redetermination hearing in front of Judge McConaughey on Monday, which is June 9th at 9 a.m. All right. And they will now handle his traffic matters. Is that all?
Excuse me, has anybody contacted David White, which is my attorney? This matter was supposed to get moved over to Judge Blout's courtroom. And I've worked on, since I've been here, I've been incarcerated 60 some days. I've taken care of pretty much all my warrants, 36th district. I've successfully completed 8 courses and got certificates. I wasn't able to get to court for this, me and not showing up. I have a 3rd grade reading and writing level. I wasn't able to use Zoom. Due to prior DUIs, I don't have a driver's license. I've never rode the bus system here in Detroit. I was unable to get to court. I did, if you look, turn myself in on the one. when they issued the warrant? Because I noticed it was a day before.
And sir, with all that being said, those are arguments that will be continued in your bond redetermination hearing, which you have on Monday at 9 a.m. But I'm going to change off to Magistrate Burton, who's going to go through your traffic matters. Hold on. Thank you. Thank you.
Okay, so Mr. Whiteside, sir, again,
Yes.
good morning.
Yes, ma'am.
Good afternoon. Okay, so you have some tickets, sir? You
Yes,
failed
I
to
just actually
appear
got,
for some court. Okay, well, let me call these. They might have been resolved, but they're before the court right now.
okay,
So you failed to appear for some court hearings and there were bench warrants that were issued. So the court's gonna set those bench warrants aside. You
Okay.
do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And if you cannot afford an attorney, one will be appointed for you. The court is calling case number SP 1203532, 5/30/2021. You're charged with driving while license suspended and no insurance. Ticket number SP 1325856, 3922. Charged with improper plates, no insurance, and driving an unregistered vehicle. Ticket number SP 1325909, 3922. Charged with driving while license suspended. Ticket number SP 1326497, 31622. You're charged with failing to display a valid operator's license. Ticket number X4112019, 9122. Charged with no operator's license. Ticket number U713014-25. Date of offense is 1/28/25. You are charged. They don't have the offense on here. Oh, loitering in the place of illegal occupation. Ticket number V 132-692, 81124. You're charged with illegal dumping. So for those charges, Mr. Wyzak, you could face up to 93 days in jail and or receive a fine in the amount of $500. The court is going to enter a not guilty plea on your behalf and set a personal bond. You have a pretrial that's scheduled for June the 23rd at 9 a.m. before Judge King. That will be by Zoom, okay?
yes, ma'am.
All right, then that concludes this matter. Okay, were these for the judge to sign? Oh, why is that? Are these his? Oh, this is why is that? This is the one the judge was supposed to. He didn't sign those. Here is tickets though signed. And then I'm gonna hand the unsigned ones back. We still have a whole stack that Judge Williams.
Am I done, Your Honor?
that still require his signature. Yes, Mr. Wyzak, sir, you are. Thank you.
Okay, thank you. Have a good day.
All right, you too. Okay, we're gonna try to keep it moving. All right, so back to DDC. Do we have any more walk-ins?
Yes, Your Honor.
Okay, who do we have, sir? Thank you for your patience. What's the name?
Her last name is Collins.
Okay.
Not me this time, Judge.
Y'all taking turns or what? Come to court. Okay. So she can step forward and then DDC, we'll get back to you as soon as we complete the walk-in. These are all the ones that.
No, the ones he didn't say.
Okay.
Just motion.
Okay. All right, ma'am, state your name, please. Oh, let's see. Did she have retained counsel? Oh, okay, so Mr. Barad, are you handling, Ms. Collins? Okay, he's on Zoom. All right then. Can you state your name, please, ma'am?
Aaliyah Collins.
Okay, good afternoon. Ms. Collins, let's see. Oh. Okay, the court is calling case number 2504-25701, the people of the state of Michigan versus Aaliyah Collins. Can I have your appearances, please?
Good morning, Lisa Coyle appearing on behalf of the people.
And Ryan Murad, PA 3665, on behalf of Ms. Collins, we waive the formal reading and stand mute. Ms. Collins has been advised of her rights.
Okay, then the court will enter a not guilty plea on behalf of Ms. Collins. And can I have a bond recommendation?
People are recommending a $20,000 bond, personal bond with an alcohol tether. This just occurred in April of this year. Although I don't see any prior criminal convictions, including alcohol offenses, this is a traffic stop for failing to move over when an officer, a state trooper, was making another stop. When she was stopped, she had a half full bottle of tequila on the floorboard. She did admit to drinking. Her breathalyzer was almost twice the legal limit at a 0.144. For those reasons, Your Honor, the people would ask for that $20,000 personal and an alcohol tether. Thank you.
What's your position, Mr. Morrell?
Judge, I'd ask for a personal bond. I don't see a need for an alcohol tether when we have a first-time OWI, no accident, walking into court. I don't see a need for that at all. I think a no drinking provision should be sufficient. There's no prior criminal history here. I believe this is an alleged first offense, no other pending matters, no probation, no parole. She's gainfully employed at Club Celebrity Soul Food, where she works full-time. She's also, despite her employment, a recipient of government assistance, putting her within the guidelines. Yes, Your Honor. Given all that, I don't think an alcohol tether is necessary. I'd ask for personal bond and no drinking.
Okay, thank you. So, Ms. Collins, ma'am, thank you for walking in to resolve this matter. The court is going to set a $15,000 personal bond. She has no priors. She has walked in. I'm not going to set an alcohol tether, ma'am, but while you're on bond, you're not to drink any alcohol. No alcohol at all, okay? And I'm certain that there'll be conditions that will be set at her pretrial by Judge Jones. You're also not to drive without a valid driver's license. Do you understand those conditions? Okay, she has a pretrial scheduled for June the 18th at 8:30. That'll be by Zoom before Judge Jones. Yes, ma'am. Well, first, wait a minute. It doesn't relate to your bond conditions or your next court dates.
Judge, if I may, just I'm gonna run in this.
Go ahead. Okay, hold on a moment. Your attorney's gonna step in. I don't want you to say anything that might go against you.
I know exactly what you're about to ask. We have nothing further, Your Honor.
Okay, then that concludes this matter. Thank you.
Thank you, Judge.
Okay, who do we have next? Go back to DDC maybe? Go back there. Okay. All right, DDC. Okay, DDC, we're ready to go again. We're officer. All right, sir, your name, please. I'm sorry, you have to speak louder. Oh. Joshua, is it he on your last name? Oh, Fowler. I have two Joshuas. I apologize. I have two Joshuas here. Okay. Joshua Fowler. All right. Good afternoon. The court is calling case number 250-579-7202. The people of the state of Michigan versus Joshua Lee Forehand Fowler. Can I have your appearances, please?
Lisa Coyle appearing on behalf of the people.
And Ryan Marad, PA 3665, on behalf of Mr. Joshua Fowler, we waive the formal reading and stand mute. Mr. Fowler has been advised of his rights.
Okay, then the court will enter a not guilty plea on behalf of you, Mr. Fowler. Ms. Coyle, do you have a recommendation related to bond?
Recommendation 5,000 personal. I do not see a criminal history for Mr. Fowler, and this is non-assaultive.
No objection.
No objection. Okay, then the court will set a $5,000 personal bond. Mr. Fowler, you don't have to post any money to get out, sir, but while you're on bond, you are not to possess or purchase a firearm or any other dangerous weapon. You understand that? Okay. All right, then you have 2 court dates. You have a probable cause conference that's scheduled for June the 13th at 8:30. That will be before Judge Robbins by Zoom. And then you have the right to a preliminary examination. That's scheduled for June the 20th at 8:30. However, that will be in person before Judge Jefferson here in the 36th District Court. Okay? All right, that concludes this matter. Thank you. Okay, see you next. Yeah, good afternoon, sir. Your name, please. Mr. Banks. Hey. All right, the court is calling case number 230-454-3601. The people of the state of Michigan versus Patrick Lamar Banks. Can I have your appearances, please?
Lisa Coyle, appearing on behalf of the people.
And Ryan Marad, PA 3665, on behalf of Mr. Patrick Banks, we waive the formal reading and stand mute. Mr. Banks has been advised of his rights.
Okay, thank you. Mr. Banks, the court will enter a not guilty plea on your behalf. Ms. Coyle, is there a bond recommendation?
Your Honor, this goes back to September of 23, misdemeanor. No objection to a $10,000 personal bond, no contact with the complainant, this Nicholas Larner.
No objection, Judge. He turned himself into.
Okay, any priors?
Yes,
priors
we have
at all,
a
correct?
2003 assault and battery.
Okay. All right, the court will set a $10,000 personal bond. Mr. Banks, sir, you don't have to post any money to get out, but you're not to have any contact with Nicholas Garner. Is that understood? Okay. Then you have a pretrial that's scheduled for June the 18th at 8:30. That will be by Zoom for Judge Bryant. Okay. All right, that concludes this matter. Thank you.
Thank you, Your Honor.
All right, sir, good afternoon. Your name, please? I can't hear you. I'm sorry, last name?
Gabriel.
Oh, okay. Is it David Owens?
Gabriel.
Is that
Shannon Gabriel? Yep.
Gabriel? Hold on a moment. Let me see.
That's a lady.
Oh, they got the lady.
Oh, no.
No, it's a guy. Yeah, it was in a different stack. Okay. All right, then. Good afternoon. Court is calling case number 25058-00001. The people of the state of Michigan versus Shannon. This is Miguel Gabriel. Appearances, please.
Thank you. Good afternoon, Stevenson for the people.
Ryan Marad, PA 3665, on behalf of Mr. Gabriel, we waive reading and stand mute. Mr. Gabriel's been advised of his rights.
Okay, the court will enter a not guilty plea on behalf of Mr. Gabriel. My recommendation, Mr. Vincent.
Magistrate, apparently unlawfully driving while possessing drugs. So we're not going to be objecting to a personal. It's non-assaultive. No driving without a license. No drugs. No driving, no drugs.
No objection.
Okay, the court will set a $5,000 personal bond. Oh, I'm sorry. Hold on a moment. Oh, he is her picture. The court will set a $5,000 personal bond. Mr. Gabriel, while you're a bond, you're not to use any drugs, possess or use any drugs. You understand that?
Ma'am.
Okay. One moment. And looks like you have some driving offenses. You're not to drive without a valid driver's license. One moment. Okay. So, Mr. Gabriel, you have 2 court dates. You have a probable cause conference that's scheduled for June the 16th at 8:30. That will be by Zoom before Judge Taylor. And then you have the right to a preliminary examination. That's scheduled for June the 23rd at 8:30. However, that will be in person before Judge Taylor here in the 36th District Court. All right, you understand your bond conditions and your next court dates. All right, that concludes this matter. Have a good day. Sir, your name, please? Mr. Hill, good afternoon. The court is calling case number 2505-798701, the people of the state of Michigan versus Joshua Liddell Roosevelt Hill. Appearances, please.
Thank you, Magistrate Steve Vincent for the people.
And Rad Marab, PA 3665, on behalf of Mr. Hill, we waive the formal reading and stand mute. Mr. Hill's been advised of his rights.
Okay, the court will enter not guilty plea on behalf of Mr. Hill. Bond recommendation, Mr. Vincent.
Magistrate, lead charge being that felonious assault with the accompanying DV. We're going to be asking for a 10,000 cash surety. We're also going to be asking for monitorization to encapsulate the incident. We have a defendant who allegedly ended up taking a glass bottle, a tequila bottle, and busting it over the mother of his child's head multiple times, causing that individual to have to go to the hospital. I ended up sending the CAD notes over to defense counsel, which outlined in the response what the police officers ended up seeing and what they did subsequent to seeing the complaining witness in this matter, the blood that was coming from her head, as well as getting her to a hospital. And in essence, the assault, at least the way that I read it, was a result of the complaining witness going on social media talking about how this defendant previously assaulted her. And apparently he didn't like that she was posting that on social media, so he ends up assaulting her. So respectfully, we find him to be a danger. It's an incident that just took place a few days ago. We find that this defendant to be a danger, at the very least, to the complaining witness. That's why we're asking for the cash with monitorization.
Okay, thank you. Mr. Moran.
Your Honor, on behalf of Mr. Hill, and I know Mr. Vincent will correct me if I'm mistaken, but I don't believe he has any criminal history, any pending matters, any history of probation or parole. He's 24 years old, Judge. He's been a resident here in the city his entire life. He lives with his mother and his brothers. He understands to reside in the alternative residence with the complaining witness. In discussing this matter with him, he candidly was very calm and understood the potential bond conditions that we advised him of, which include no contact, no weapons, things of that nature. I believe there's a little more to it than that's contained in the investigator's report, but given the fact that he doesn't have any prior criminal history, there's not a domestic pattern of charges, at least that I'm aware of. I would ask the court to consider a personal bond here. I think if you can go as far to set a tether and even do a house arrest if you must, Judge, but he's not employed right now. I'd ask the court not to consider cash bond. I know the allegations are serious, they are assaulting, but I do believe that Mr. Hill is a good candidate for a GPS tether, given his lack of criminal history. And just reading this, it doesn't seem that this is an escalating issue. Although I did acknowledge Mr. Vincent's position with regard to what the first video or social media issue was about. But that's my request, Your Honor.
Okay, thank you. Looks like the plaintiff witness has an address that's also on Mendota. So
He's not going
you
to
said
stay
your
there,
client
Judge. He's
he does have somewhere else to go.
Yes, we just asked for a one-time police escort. I mean, even if you have to skip that, Judge, I mean, we're hopeful that he just gets out.
All right, one moment. So, Mr. Hill, sir, these are some serious allegations. I don't know what was going on and, what was posted that appears to be upsetting, but whatever it was that was posted to the internet caused things to spiral out of control. So the court because you have no priors, the court is gonna impose a tether, but it's gonna be house arrest. So you're gonna get a $25,000 personal bond. But you're gonna be under tether house arrest. While you're on bond, sir, you are not to have any contact with it looks like Kate Aaliyah Smith, and you're not to go to or enter the Mendota location. Do you understand those conditions? Yes, I'm talking to you, Mr. Hill. Okay. All right, you look at it like, who you talking to? I'm talking to you. All right. One moment. Okay, then Mr. Hill. You're also not to possess any firearms or any other dangerous weapons, purchase or possess. Okay, you have a probable cause conference that's scheduled for June the 16th at 8:30. That'll be before Judge Jakay by Zoom. And then you have the right to a preliminary examination. That's scheduled for June the 23rd at 8:30, but that will be in person before Judge Jakay in the 36th District Court. Okay, that concludes this matter.
Thank you. Thank you, Ron.
Mr. Gross looks like he's back. We resolved this case, correct? I'm gonna admit him, let him know.
Perfect. And I got a court date for him to give him too.
Okay, great. Mr. Gross? Mr. Gross, sir, unmute your device and turn on your camera. Ahmad Gross. Oh, okay. Mr. Gross? Mr. Gross, you could unmute you unmuted. Can you put your camera on, sir? Or at least acknowledge that you can hear us.
Sir. Okay.
Okay,
Yeah,
this is the lady. My voice is deep.
Yeah,
Okay,
okay.
so your matter was already resolved, Mr. Gross. I believe he had a bond that was continued. Okay,
Yeah,
so
he posted
Mr.
the bond
Barad,
already.
you want to give Ms. Court dates,
So-
Mr. Barad? I don't have his file
Yeah,
right now.
you're on your June 13 before the Honorable Judge Robbins at 8:30 a.m. Okay?
Is that in the courtroom?
It's on Zoom, but if you can't get there on Zoom, make sure you pull up in person.
Okay.
Judge Robbins, June 13, 8:30. Do you got somebody next to you to write that down? You want to put it in your phone?
Yeah, and also is there a specific meeting ID number I need?
Absolutely. Absolutely.
Mr. Murad, I can go in the breakout room. Judge, you can put me in the breakout room, Mr. Gross, real quick. Y'all can move. I still have a couple
He's right
questions.
there. I'll let him give it to him and he can.
But I
Go
still
ahead,
have,
Mr. Murad. You got to interview somebody else or you got to tell him
still
something?
need to talk to Mr.
We just
Gross.
got to get him in the breakout room.
Yeah.
Okay, give me a
Come in the
minute.
breakout room. Yeah.
All right, so, Gross. Hoping I have those rooms still open.
Hey, what's up?
My assignments, hold on. And, oh, I see you on here, Mr. Reagan. Hold on. Mr. Reagan? Oh, because I had you in there. You got it?
Shit. For the join.
It's not going. You got join on yours?
Nope, I don't.
Is yours? Okay, so let me try room 2. For some reason, it's not letting me. Oh.
I really just need a phone number for Mr. Gross. I hate to put it over Zoom. That's why I want.
But
Yeah,
I still need that meeting ID number too for the 13th.
I know. I don't know what happened when I switched hands. Because now my breakout rules, I'm gonna have to close them, I guess. And open it back up because it is not letting me assign them. And I don't know why. It's close. Did you ever close out of?
What'd you say, Judge?
Yeah, hold on a minute. Okay, for whatever reason, it's not letting me assign. Okay, we're gonna have to move on. Somebody give him your phone number, well, your number, unless it's the office number, right?
313.
Okay, then. Mr. Gross, take this number down.
Yes, I'm listening.
313-965.
Okay, go ahead.
313-965-6777.
Not 313-965-6777.
Yep, call me right now.
I'll call you now?
Yep.
Okay.
Yeah, okay. I don't know what happened. Thank you, Mr. Gross.
Thank you.
All right, then, sir, at DDC, your name.
David E. Owens.
Okay, let's see. Owens? Okay. Good afternoon, sir. Mr. Owens, you have some tickets, and I'm going to address those tickets first. You failed to appear for a couple of court hearings, and some bench warrants were issued. So I'm going to set those bench warrants aside. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. Court is calling. Ticket number SP 1178420-32621. You're charged with failing to display a valid operator's license and driving an unregistered vehicle. Ticket number SP 9842266 4/5/2019. You're charged with, hold on. No insurance and driver's license never acquired. For those charges, Mr. Owens, you could face up to 93 days in jail and or receive a fine in the amount of $500. Court is going to enter a not guilty plea on your behalf, set a personal bond, and you have a pretrial that's scheduled for June the 20th at 9 o'clock before Judge Perkins. That will be by Zoom, okay? All right, I'm going to move on to your main case. Would you restate your name for the record, please? Okay, court is calling case number 210-6207401. The people of the state of Michigan versus David Owens. Appearances, please.
Coyle appearing on behalf of the people.
And Ride Maran, PA 3665 on behalf of Mr. Owens. We waive the formal reading and stand mute. Mr. Owens has been advised of his constitutional rights.
Okay, then the court will enter a not guilty plea on behalf of you, Mr. Owens. Ms. Coyle, you have my recommendation.
Recommending a 5,000 personal, no driving without a valid driver's license.
I agree, Judge.
Okay, court will set a $5,000 personal bond. And Mr. Owens, sir, you are not to drive unless you have a valid license. You understand? Do you understand, sir?
Yeah.
Yes. Oh, okay. I didn't hear you. Okay. I'm driving without valid. This is Mr. Owens that we're doing right now. And 5,000 personal. Okay, you're welcome. Okay. Somebody's calling. No driving. Okay. All right. So, Mr. Owens, you have 2 court dates. You have a probable cause conference scheduled for June the 16th at 8:30. That'll be by Zoom before Judge Taylor. And then you have the right to a preliminary examination. That's scheduled for June the 23rd at 8:30, but that will be in person before Judge Taylor here in the 36th District Court. You understand? Okay. All right. That concludes your matters. Have a good day. You're welcome. Okay, looks like we have a couple of more males and a couple of females. Okay. Right.
Yeah.
Take your EIN bit and put it in the short.
Okay, we hear you. We hear you, Ms. Harris.
Oh, sorry.
That's okay. I know if you want everybody to know all your business. All right, DDC, just you guys forget about us? Two more.
Yes.
Okay, DDC, did you guys go to lunch early? Okay, thank you. Oh, okay. Oh, that was the one that interpreted. Okay. Can we call over to DDC and see what happened?
Judge, how many more mails do we have left? Did we just run through them?
We have 2.
Which ones do you still have, Your Honor?
So I have Rios, Saul Rios, number 17 and number 20.
So Rios is a walk-in.
Oh, Carter, we did. Oh, Rios, we did Rios already?
No,
Oh,
Rios
he
is a
didn't,
walk-in
he
that
didn't
never
appear.
appeared.
Oh, I do sure said, okay, let's see what's going on with the other one. Oh, the
I
other one
think
was the
Carter-
county jail. So
Division
DDC.
one.
Oh,
Division 1 in Wayne County.
You have Carter also? I have Carter.
Yep, for Division one.
yeah, so that's the county jail. Oh,
Yeah.
we call it DDC, we should call it county jail.
Cause I was looking, I only had females left.
Okay, then. So Mr. Rios did not walk in, so let me put on here. Oh, he left.
I'm saying he checked in at the information, but
Maybe they told him this afternoon, I don't know. Did not appear, okay, okay, and left. Okay. Okay, so we should be on the female side, and we have two.
we have somebody here in the gallery,
Oh, for who?
Carter. Division 1. What's the
I see there's a, so off screen.
Mr. Burton, how are you?
I'm doing good, how are you?
Well, you ready for the females?
Yeah, so we doing all the males? Okay,
Sure.
yeah, the last one was at the county, so we ready for the females?
How bad? I thought it was for the female side.
Okay, thank you. Here's back on Ms. Johnson on my telephone. That's a different file
they didn't answer, so
than the release orders. Okay.
it was different. All right. Then give me a second.
They chiming back in. They're gonna chime back in.
Or
they on
No,
there.
I didn't get an answer over here when I called, so I just said, I'm having a manager for that call.
Oh, okay. Thank you.
Paperwork, something.
Oh, there we go. DDC. Okay, ready, DDC female? Female side.
That's the full name.
Okay. Good afternoon, ma'am. Okay, the court is calling. Case number 25-058-00101. The people of the state of Michigan versus Samelia Bashita Mimel. Okay, appearances, please.
Lisa Coyle appearing on behalf of the people.
And Ryan Marad, P83665, on behalf of Mr. Mamel. Ms. Mamel, we waive the reading and stand mute. Ms. Mamel's been advised of her rights.
Okay, the court will enter a not guilty plea on behalf of you, Ms. Mamel. And Ms. Coyle, do you have a recommendation for bond?
Your Honor, the people are recommending a 20,000 cash surety and no contact. I do not see Ms. Mamel having any criminal history that I am aware of. The complainant in this matter is her mother. Her mother is 70 years old. What is troubling is when the officers came to the front door, the defendant allegedly told them there was no assault that had taken place, but the complainant, her mother said there was, that it was an argument that turned into a physical argument where the complainant stood on this woman's oxygen tank cord and basically said, "What are you going to do about it?" She then choked her on the couch to the point she almost passed out. The granddaughter, who is 6 years old, witnessed this. There's allegations that, per the mother, saying the defendant has mental issues. Your Honor, I believe that those allegations indicate that Ms. Mamel is a danger to her mother. Ms. Howell, based on the fact she's 70, she's older, she's using oxygen to assist her breathing, and that she not only choked her, but tried to cut off her mode of breathing. Based on that, people believe she's a danger and asking for the 20,000 cash surety. Also, it appears they reside together and ask her not to be able to go back to that household.
So,
thank you.
So, Your Honor, we disagree. We think that, in talking to Ms. Mamel, she's her mother's caretaker. Her mother suffers from dementia. I've seen this kind of case come through a lot, where the complainant is under the impression that they're being attacked or harmed. There was never any sort of assault that took place. We talked to Ms. Mamel thoroughly about this. She has no criminal history whatsoever. Her mother is frail, as indicated by the people. She's going through her own medical and mental issues. She'll stay away if she has to, but she's the only person to care for her mother. Obviously, she's completely disputing this choking and this oxygen take. I mean, she's the person who makes sure her mother's getting the care. Her father had passed away, so she moved in with her mother, brought her daughter with her for the purpose of caring for her mother. There was never, Ms. Mamel doesn't have any hostility, or there was never an issue to make Ms. Mamel upset with her mother. This is a situation where, unfortunately, we believe that based on her dementia and her crumbling mental health and her old age, that Ms. Mamel's mother is suffering from, what we would call maybe hallucinations or different, positions where she feels that Ms. Mamel is the antagonist of the story, and that's really not the case. This is really sad and unfortunate. Obviously, we all have a legal duty. Ms. Coyle has a duty to argue what's in this report and on behalf of the complainant, and I have a duty to tell you what my client tells me and argue on her behalf. And obviously, the court is stuck with this situation. There's no criminal history here whatsoever. All she's ever done was, she's a mail carrier at the U.S. Post Office. That tells me she's passed background checks. No pending matter. She's not on bond for anything. She's a 6-year-old daughter and her mother that she's living with. We would ask judge to release her on personal. She'll go find somewhere else to stay. I'd ask for a one-time opportunity for her to go, obviously, pick up her 6-year-old daughter and relocate. But we believe that she poses absolutely no threat. And I think with the proper time and further investigation, that Ms. Mamel's name should be cleared of this. But for all those reasons, I'm asking you to release her on a personal bond. No contact is fine. We just ask for a one-time escort to get her daughter.
Your Honor, I just would like to interject one thing before, and I usually don't come back and say something unless need be, but I'm looking at the complainant's statement, and she's very detailed as to what the argument was about. Apparently, she gave the 6-year-old some bubble gum, and Ms. Mamel did not want that to happen, and it turned into a fight. So before a woman is declared to have dementia at 70, which is awfully young for dementia to that point that she is not sure of what occurred. I think that based on what we have to go forward is not only that the prosecutor interviewed this person, the police have too, and made a determination. At this point, there was probable cause to determine that this woman was lucid enough and knew what she was talking about, and evaluated the situation. And here we are, not to second guess with somebody's life because someone says she's at 70, which is young to be suffering from that state of dementia. So that's why I just, and I'm not saying Mr. Murad is not saying anything his client hasn't told him. So as an officer of the court, he's a fine lawyer and I trust his word. But I think we have to look at what we all here are to deal with. Somebody is telling somebody that this person's crazy at 70 or has dementia and does not know what they're talking about. And I think that's a big leap for this court to take based on the allegations that it was interesting, that the mother at the scene did say that happened. And then later when she talked to the prosecutor, she said the same thing happened. So there must be something to it, Your Honor. And I guess that at this point, there's enough here that the court and that the police and the prosecutor at least believed on probable cause that there was sufficient evidence or allegations to go forward. Thank you.
Okay, thank you. Mr. Murad, your client does have another location that she can go to and provide an address to the court.
So yeah, we talked to her about this. Her plan, I mean, she has enough money to get a room. So she's gonna get a room and get on her feet, but she's not gonna stay there and she will have another place to be at.
Okay, all right. Well, Ms. Mamel, the court is concerned about these allegations and I don't know what happened. It sounds like there's some other issues that perhaps are going on with you, according to the report. And so I don't know whether your mother has dementia or whether they're hallucinations or not. The court is not trying this matter today. The court is concerned about the allegations, appears very serious in terms of what she's alleging that happened at that location. First, the court will indicate that you cannot return to the Frisbee location. She has belongings that are still there, Mr. Murad?
Yes, Your Honor, but most importantly, her daughter. Her 6-year-old daughter.
Okay.
But yes, she also has her clothes and things of that nature.
Okay, so she may have an escort, one-time escort to go to that address to pick up her belongings and her child. And you're not to have any contact until this matter is resolved, ma'am. You're not to have any contact with, looks like Aranette Howell. That's your mom? That's your mother? Okay, so while these allegations are pending, you're not to have any contact with her. Because she is not, says she's gonna provide an address to the court. The court is going to, oh, she's working as a mail
Yeah,
carrier?
she's a mail carrier at the U.S. PO judge.
It's an east, not an east.
Sorry, I didn't hear what she was saying, Mr. Murad. Did you want to clarify?
I don't think she said any, no, she didn't say anything, but she works at the U.S. Postal Office, Judge, as a mail carrier.
Okay, all right, the court is,
Sorry, right?
going to set a 10,000 cash surety bond. It's based on the allegations. The court does find by clear and convincing evidence that some cash bond is appropriate. However, as it relates to a tether, will just be a no contact tether. So ma'am, you cannot have any contact with that address and not with your mom.
Judge, is the court ordering tether too?
Yes.
Your Honor, is there any way the court would, given that the fact that you've imposed tether, consider a deviation back to personal, just because she's gonna lose her job, she's losing her place, and obviously you know our position. I hear both sides, I get it, but I do think that a GPS tether, since you're already imposing it, is gonna accomplish the same things. Remember, this is somebody with no prior criminal history, somebody who's gainfully employed, past federal background checks to work at the US Post Office. You know, this will turn her life upside down. She's going to lose her job. Everything will go downhill with a bond like that, Your Honor. And I understand, but I would just hope maybe the court would consider GPS work only at a different location.
No, but the court will consider a 10%.
Okay. So, Ms. Mel, I see your hand up. I don't want you to say anything about the case. Okay, if you have a question about a court date or a bond condition, you can ask that. It's your right. But I really don't want you to say anything that will happen or what didn't happen. I don't want us to get into that on this record, okay?
Near the house.
As long as you're not at the house and you're taking your daughter to the school, you're not going to be violated on your tether.
Okay.
Okay, hold on one moment. Okay, so I have tether no contact, and then we'll 10% of 10,000. Okay, then Miss LaMayo, you have two court dates, ma'am. You have a probable cause conference that's scheduled for June the 16th at 8:30. That will be by Zoom before Judge Jakay. Then you have the right to a preliminary examination. That's scheduled for June the 23rd at 8:30. That will be in person before Judge Jakay here in the 36th District Court. As it relates to that bond, is that affordable or unaffordable, Mr. Murad?
Unaffordable, Judge.
Then you'll also have a bond redetermination hearing on Monday, June the 9th at 9 o'clock before Judge McConicle or Judge Williams.
Thank you, Your Honor.
All right, that concludes this matter.
Thank you.
Okay, well, this will be the last. Oh, sir, your name. That must be Mr. Carter. Okay.
Judge, we
we'll
need
be with
him
you shortly.
to be interviewed.
Oh,
Carter
we
needs
need
to be
Carter
interviewed.
interview. Yeah, you know what? For whatever reason, I don't know what's going on with these breakout rooms. They're not allowing me to assign. Let me go back. Who's gonna interview him?
I'm gonna have a colleague zoom in now. Yeah.
Not let me assign anybody. And then, sir, that's up in number 11. F11, what's your name? Mr. Reagan, I don't know what is going on here, but it is not allowing me to assign anyone.
You want us to call IT, Your Honor?
Yes. Not allowing me to assign. Okay, all right, ma'am. What's your name?
Shamika Norfolk.
Call IT for me. Okay, good afternoon, Ms. Norfolk. Court is calling case number 220-565-8501. The people of the state of Michigan versus Shamika Norfolk. Appearances, please.
Benson for the people.
Miguel Abrico, P88379, on behalf of Ms. Norfolk. Judge, my client's been advised for constitutional rights, waives the formal reading of the complaint, stands mute, requesting a not guilty plea be entered on her behalf.
Okay, hello, Mr. Brico. The court will enter a not guilty plea on behalf of Ms. Norfolk. Okay, by recommendation. Mr. Benson, are you on this matter?
I am. Magistrate, I have to pick my battles with you. I have a sensitive ego. I don't want you shattering it. This is an incident that took place almost 4 years ago. Serious charges. You can see the allegations. I'm not going to be objecting to a personal bond. Erring on the side of caution, seeing as though this defendant allegedly hit her mother with a motor vehicle, I would be asking for a no contact provision through the pendency of the case. Any other conditions you feel appropriate?
Okay.
The defense has no objection to personal bond, nor no objection to the no contact. My client indicated she has a different address that she can stay at during the pendency of this case.
All right. Okay, Ms. Norfolk, the court will set a $20,000 personal bond. And this Archdale location, let's see. I see this happened on Penrod, so she doesn't live on Penrod, does she?
No, Judge.
Okay, all right then, but she's not to go to that location.
Okay.
I'm just adding that condition here. Okay, so Ms. Norfolk, while you're on bond, you're not to have any contact with Tanya Norfolk, your mom, unless you get further instructions from a judge to do so. And you're not to go to or enter the Penrod location. You understand? Okay, all right, and she has 2 court dates. You have a probable cause conference that's scheduled for June the 13th at 8:30. That'll be by Zoom. And then you have the right to a preliminary examination. That's scheduled for June the 20th at 8:30. That will be in person before Judge Giles here in the 36th District Court. Okay, you understand your bond conditions and your court dates. All right, that concludes this matter. So, yeah, we're trying to, did somebody call IT for me?
Yeah, I have IT on right now. They're about to transfer the digital.
Oh, okay.
Your Honor, I might have you pick up the phone because he's in that quick. Hold on one second.
Thank you, Magistrate Barton. We'll see you this afternoon.
Okay, thank you. Hi, IT. I'm doing good, thank you. So for some reason, I'm having difficulty assigning my breakout rooms. Okay. Thank you. You got me? And then something was put at the bottom. Would you like to? Yes, okay. Would you like him? Do I need to push yes again? Okay. Yeah, I'm trying to put him in the breakout room and it's not, where there's a breakout rooms. I know, so, two, okay, so hold on a minute. So we had, interview room, we had number 10. But it won't say, when you hit it, it will not say, you know, assigned to. Well, it's 1, 2, we have 2, 3, and 4. Mr. Reagan was previously in 1. Okay. Oh,